She was 7 years old when they took her father away. She was 22 when she got him back. In between those two dates was a letter, 6 pages, handwritten on legal paper, sent to the State Attorney General's office on a Tuesday in March by a young woman who had spent the better part of her life collecting the truth about what had happened to her father, and who had finally found the person with both the authority and the willingness to read it. The letter contained 3 things: a timeline she had assembled from 15 years of public records requests, court documents, and interviews with witnesses who had never been asked to speak. A pattern she had identified across 11 other convictions from the same court, the same judge, the same prosecutorial partnership, all following the same structural logic. And a specific piece of evidence, a single document, that had never appeared in the original trial record, which she had obtained through a records request so narrow and so precisely targeted that it could only have been filed by someone who already knew exactly what they were looking for. Her name was Imani Reeves. Her father's name was Calvin Reeves. He was 56 years old. He had been in Lone Oak Correctional Facility for 15 years, 3 months, and 11 days for a crime he did not commit, sentenced by a judge who had known, who had been given every reason to know, that the man in front of him was innocent. When the Attorney General's office read the letter, they called Imani the same afternoon. When they finished reading the file she sent the following day, they opened a formal investigation. 18 months later, Calvin Reeves walked out of Lone Oak Correctional through the front gate in the same clothes he had worn in, slightly too large now, into a September morning where his daughter was waiting. She was holding the folder that had started everything. Go back 23 years. Calvin Reeves was 33 years old in the year the arrest happened, a forklift operator at a regional distribution warehouse in Crestwood, Arkansas, a deacon at his church, a husband, the father of a 7-year-old girl who was, by everyone's description, the center of his world. He coached her soccer team on Saturday mornings. He read to her every night. When she lost a tooth, he wrote the Tooth Fairy letter himself in a looping cursive she recognized as his even at 7 years old, and kept anyway, because she recognized it. He was not a man with a criminal record. He was not a man with enemies. He was a man who had been in the wrong place with the wrong skin color when a crime occurred that the local prosecutor, a man named Jeffrey Haynes, needed to close before an election. The crime was an armed robbery of a convenience store on Route 9 in October. The actual perpetrator, a fact that would not emerge fully for another 14 years, had been identified by 2 witnesses at the scene who gave statements that described a man of a different build, a different complexion, and a different vehicle. Those statements had been taken by a patrol officer named Darren Cross, who had filed them in the incident report and then watched them disappear from the evidentiary record through a process that he would spend 12 years telling himself was above his pay grade. Calvin had been pulled over 3 blocks from the store, 20 minutes after the robbery, driving home from a union meeting. His car matched, loosely, the way that any dark sedan matches another dark sedan at night, the description of a vehicle seen in the area. He was brought in for questioning. He was cooperative. He told the truth about where he had been. He had 7 witnesses from the union meeting who could place him there for the 2 hours before he left. Only 3 of those witnesses were ever contacted by his public defender. The public defender was 26 years old, 8 months out of law school, and handling 43 active cases. He did his best. His best was not enough. Jeffrey Haynes presented the case with the practiced confidence of a man who had learned that a confident presentation in certain courtrooms, in front of certain juries, with a defendant who looked a certain way, did not require an airtight factual record. He had 3 pieces of evidence: a partial eyewitness identification that he described to the jury as a positive ID, A cell tower ping that placed Calvin's phone in the vicinity of the robbery. The same vicinity where, by Calvin's own account, he had been driving home from the union meeting, and a video from the store's external camera that was too degraded to make out a face, but that Haynes described as consistent with the defendant's build. Judge Raymond Fowler presided. Raymond Fowler had been on the bench for 19 years. He had come up through the same political network as Jeffrey Haynes, the same party, the same donors, the same county power structure that had been re-electing both of them in a county where the machinery of that re-election was not complicated to operate. He was not, technically, corrupt in the transactional sense. No money had changed hands. What had happened was something older and quieter than bribery. A shared set of assumptions about whose guilt required real scrutiny and whose guilt could be processed efficiently, and a decade-long pattern of rulings that processed the two categories accordingly. Calvin Reeves was convicted on all counts by a jury that deliberated for 4 hours. He was sentenced to 15 years. He heard the sentence in a courtroom where his wife Denise was in the gallery with 7-year-old Imani on her lap. He did not cry. He looked at them and held their eyes, and then he looked at his attorney, who was already gathering papers, and then he looked at the judge. The judge was writing on a notepad. He did not look up. Denise filed the first appeal herself through a legal aid organization 18 months after the conviction. It was denied on procedural grounds. She filed a second appeal 2 years later through a different organization that had taken an interest in the case after a paralegal there read the original trial transcript and flagged the eyewitness identification issue to her supervising attorney. That appeal was denied too, on the grounds that the evidentiary threshold for post-conviction relief had not been met. She wrote letters to the State Innocence Project. She wrote to the ACLU. She wrote to every organization she could find whose mission included the kind of case her husband's was. She received responses ranging from sympathetic to form-letter bureaucratic that all amounted to the same practical answer. Without new evidence, the standard for overturning a conviction was higher than the existing record could reach. New evidence. That was the door. And the door had been locked from the inside by the people who had built the case. Denise kept working. She kept driving. Every other Saturday, 3 hours each way, so that her daughter could have 1 hour at a table with her father. She kept that schedule for 11 years without missing a single visit. Not for illness, not for weather, not for the 2 occasions when the facility went on lockdown and the visit was conducted through glass instead of across a table. She showed up because showing up was what you did when something mattered, and because she understood, on a level that went deeper than strategy, that Calvin needed to see his daughter growing and that Imani needed to see her father intact. Imani grew up watching her mother work. She watched the letters go out and come back. She watched Denise organize the files in a system of color-coded folders that lived in 2 banker's boxes in the bedroom closet, updated after every filing and every denial and every phone call with every attorney who had ever looked at the case. She absorbed this, the value of the record, the discipline of the system, the way children absorb what they live inside. She was 10 when she started keeping her own records. Not because anyone told her to, because she had watched her mother do it for 3 years, and because she understood, in the way that children understand things they have absorbed rather than been taught, that the record was the thing. That if the door was locked from the inside, the record was the key. You just had to keep adding to it until it was the right key. She started with the case file, which the legal aid attorney had given Denise a copy of. She read it at 10 years old, slowly, with a dictionary beside her for the legal vocabulary. She did not understand all of it. She understood enough. She understood that there were 2 witness statements in the police report that described someone who was not her father. Different build, different complexion, different vehicle. and that those statements appeared nowhere in the trial record. She wrote this down in a spiral notebook she labeled, "Things That Don't Match." That notebook was the first of 9. By the time Imani was in high school, she was submitting public records requests through the county clerk's office under her mother's name. The clerk, a woman named Agnes Turner, who had worked in that office for 30 years and who recognized the pattern of a persistent family fighting for a wrongful conviction when she saw one, processed every request without comment and occasionally, in the way of a person operating at the edge of what her job permitted, mentioned in passing that certain record categories existed that families sometimes found useful to request. Imani followed every one of those mentions. By 16, she had a document trove that her mother's attorneys had not assembled. Not because the attorneys weren't capable, but because the attorneys had been working through formal legal channels that moved at the pace of formal legal processes, and Imani had been working through public records channels that moved at the pace of a teenager, with nothing but time, and the particular focus of someone who has spent every other Saturday of her childhood at a plexiglass window. The pattern became visible in her junior year of high school, when she had enough cases to compare. She had been tracking the outcomes of the Crestwood County Criminal Court under Judge Fowler for 4 years, not secretly, not officially, just systematically, pulling docket records and outcome data and comparing them against the demographic breakdown of defendants and the prosecutorial patterns of the cases Jeffrey Haynes had brought. The numbers were not ambiguous once they were organized. Black defendants in Fowler's court, charged with property crimes prosecuted by Haynes, were convicted at a rate significantly higher than white defendants charged with comparable offenses. The average sentence was longer. The appeals were denied at a higher rate. She presented this to her app statistics teacher as her semester project. The teacher, who had been expecting Excel charts of sports data and population trends, read it twice and then asked Imani to stay after class. He said, "Do you know what this is?" She said, "I know what it is. I need to know who to send it to." He gave her the name of a journalism professor at the State University who did investigative data work. The journalism professor read the project and suggested she contact a law professor at the same institution who specialized in prosecutorial misconduct. The law professor read the project and said 3 words: "Don't stop digging." She didn't. The document she found in her second year of college was the one that changed everything. It was a memo, 2 pages, typed, on the official letterhead of the Crestwood County Prosecutor's Office, dated 4 days before Calvin's trial. It was addressed to Jeffrey Haynes from one of his investigators, a man named Paul Driscoll, who had since retired to Flagstaff and who would, when the Attorney General's investigator reached him 18 months later, confirm the memo's authenticity without hesitation, and with the particular relief of a man who had been carrying something heavy for a long time and had finally been given permission to set it down. The memo described the results of a follow-up interview with the store's owner, conducted at Haynes's specific request. The store owner, who had not been called as a trial witness, whose name appeared in the case file but not in the trial transcript, had reviewed the external camera footage a second time using better playback equipment that the police department had recently acquired. His conclusion, as recorded by Driscoll, was that he was no longer certain the person in the footage was the same build as the man who had been arrested. No longer certain. Those 3 words in an official document in the possession of the prosecutor 4 days before trial had never been disclosed to Calvin's defense. This was not a procedural technicality. Under Brady v. Maryland, the 1963 Supreme Court decision establishing that prosecutors must disclose exculpatory evidence to the defense, a document recording a key witness's doubt about the central identification evidence was not optional to disclose. It was constitutionally required. Withholding it was a Brady violation, and a Brady violation, properly documented and argued, was the kind of ground on which convictions could be overturned. Not easily, not quickly, but with the right attorney and the right record. With the force of a constitutional guarantee that had been violated specifically and provably. Imani had found the memo in a box of files that had been transferred to the county records archive when the prosecutor's office underwent a digital system migration 5 years earlier. The physical files had been cataloged by box number, and the catalog, a public document, had been cross-referenced against the case number in her father's trial. She had submitted a records request for the specific box. Agnes Turner had processed it in 6 business days. Imani had been sitting in the university library when the scan arrived in her email. She had opened it, read the first paragraph, and then sat very still for a long time, while the understanding of what she was looking at settled through her, like water finding its level. She forwarded it to the law professor without a message. He called her 19 minutes later. He said, "Imani, this is it." She had said, "I know." She had known from the first paragraph, but she needed someone with standing and experience to confirm it, because the next step required more than knowing. It required building the presentation of what she knew into something that could not be dismissed by the people it would threaten. She spent 3 weeks writing the letter. 6 pages. Handwritten, because she had thought carefully about what a handwritten letter from a 22-year-old woman would communicate that a typed submission would not. That this was a person, a family, a specific human cost attached to every page of every document she was about to send. The letter laid out the 15-year timeline, the statistical pattern across 11 cases, and the Brady violation in that order, structured to build from context, to pattern, to evidence, with the architecture of someone who had spent 15 years learning exactly how to make a case from the materials available. She addressed it to the Attorney General by name. She sent it certified mail on a Tuesday in March. His office called that afternoon. The investigation lasted 18 months. It was not fast, and it was not clean. Because the systems that produce wrongful convictions are the same systems that resist examining them, and every step of the process required documentation, legal challenge, and the particular patience of people who understand that the right outcome is not guaranteed by the quality of the evidence, but by the persistence of those who carry it. Geoffrey Haynes, now in private practice, was disbarred following the investigation's findings on the Brady violation and a broader pattern of prosecutorial misconduct documented across 7 of the 11 cases Imani had flagged. He did not issue a public statement. Raymond Fowler had retired from the bench 3 years before the investigation began. The investigation's findings regarding his pattern of rulings were referred to the State Judicial Conduct Commission, which opened its own proceeding. He died before it concluded. The proceeding was closed. The record remained. The conviction was vacated by the State Court of Appeals on a Wednesday morning in September, 14 months into the investigation. Calvin's attorney, not the 26-year-old from the original trial, but a senior wrongful conviction litigator who had taken the case on referral from the law professor 18 months before, called Calvin at Lanoke Correctional to tell him. Calvin Reeves sat in the phone room for a long time after the call ended. The room was small, 4 phones on a wall, institutional green paint that had been layered over older institutional green paint until it had the depth of something geological. He had spent 15 years inside rooms like this one, rooms that contained you, that defined your perimeter, that had a specific smell and a specific acoustic quality that you stopped consciously noticing after the first few years because the alternative was too heavy to carry. He sat with the news for a while and let it be real. The guard on duty, a young man named Samuel who had worked the block for 2 years and who knew Calvin the way guards know long-term inmates, by the quality of their patience, by the way they treated the people around them, by the books stacked beside their bunk, came over after a while and asked if he was all right. Calvin said, "I'm going home." Samuel looked at him for a moment. Then he said, "Congratulations, Mr. Reeves." Calvin nodded once. He picked up the phone again, not to call anyone, just to have something to hold while he sat, with the morning becoming a different morning than any morning had been in 15 years. He walked out of Lone Oak Correctional on a Thursday morning in September, 4 days after the vacation order was entered. He was wearing the clothes he had worn in, slightly too large, fabric softened by 15 years of institutional washing, and he was carrying a cardboard box of books. The books were the ones Imani had recommended in her letters over the years, the ones he had read and annotated in his small, neat handwriting and kept in a stack beside his bunk as a kind of library of the life she was sending him dispatches from, while he waited to rejoin it. Imani was standing at the gate. She was holding the folder, the original one, the one with the 9 notebooks worth of documentation that had started with a 10-year-old reading a case file with a dictionary. She was 22 years old. She looked like her father around the eyes. He came through the gate. He stopped in front of her. He looked at the folder. Then, he looked at her face. He said, "You did this." She said, "We did this. You and me and Mama and Agnes Turner and the professor and everyone who didn't stop." He pulled her into his arms. She held on with the grip of someone who has been waiting to do exactly this for 15 years and is now making up for all of it at once. The September morning was clear and cold. The parking lot was ordinary. Asphalt. A few cars. The flat light of early autumn. There was nothing cinematic about it except everything. The state legislature passed a wrongful conviction compensation statute the following year, modeled in part on the findings from Calvin's case. Imani, by then in her 2nd year of law school, submitted written testimony to the committee that was drafting the bill. The committee chair, reading her testimony aloud during the hearing, paused at one passage and said, "This is the kind of thing that should be taught. It is, now, in one form or another, in 2 law school clinics and an undergraduate justice studies program, the story of what a systematic record, built over 15 years by a child who refused to stop looking, can do when it finally finds the hands that know what to do with it." Denise Reeves does not speak publicly about the case. She has earned that quiet. Calvin works now at a reentry organization in Crestwood, helping people navigate the transition from incarceration to the lives waiting for them on the other side of the gate. He knows what that transition costs. He knows what it requires. He shows up every day with the particular authority of someone who has come through the worst of a thing and chosen to turn it outward. The shoebox under Imani's childhood bed still has the letters. Every one of them, in date order. She hasn't moved them. She doesn't see any reason to.